Welcome. I think we can get started now. We've got a long, well, somewhat long, but interesting day ahead of us. Hello, and welcome to the annual ADC-ICT's conference. For those of you that don't know me, my name is Dragan Dan Ivitic. You can call me Danny, and I have the pleasure of being the current president of the ADC-ICT. And it's my job to welcome you today and to get this show on the road. I hope you're all excited about this, as I am. I still remember when I first came to The Hague back, 1999-ish, there was not an ADC at that point in time, and it was a whole new world. But the one thing that I did appreciate at that time is all the practitioners, the defense practitioners, were a tight-knit community. There was a lot of information exchange between people, helping each other out, and I think that then followed and began with the ADC and reached new grounds, where the ADC is now known historically as a body that not only advocates for defense rights, but facilitates the exchange of information, training, and we also have one of the most highly sought after and premier social events every year that has historically been a very popular event, and this year as well. I do want to advise you at 7:30 and onwards in the evening, or 19:30 if you want to go with European time, we will be at the bar and restaurant Suzy Q, which is in the Tweede Haven, the second harbor on Dr. Lelekade. So please join us. That's a great opportunity to ask questions that you perhaps were, a little bit too shy to ask today. But we're going to have a microphone going through the crowd, so if you do have questions of our panelists, please do take the opportunity. That's why we have these events. So anyway, today we have 3 panels with very interesting topics. And we have a lot of information to give to you, so my part is done. I'm at my 5 minutes. So, the first panel, thank you very much.
Thank you, Danny. Just going to check that everyone can hear in the back when we get started. Welcome to panel 1, Everything ICL All at Once, where we're going to talk about different versions of fair trial rights experienced, of course, across the ICL metaverse. I don't know if we actually have 5 separate attorneys here or if it's one attorney just experiencing things across the courts and tribunals. But when we put this panel and this conference together, I have to give a little bit of credit to Kate Gibson sitting next to me, because we were discussing what themes we wanted. And often we look to the future. What can we do in the future to really be ready and arm ourselves for these trials? But Kate said, we have to get back to our roots. She said, let's get back to discussing the fair trial issues that we see every single day in courtrooms. So this is going to be a bit of a retrospective of the last year. What's happened in the last year that we actually want to talk about when it concerns fair trial rights? And I was thinking about this because it is almost December. And I was thinking, I haven't celebrated a Festivus in years. So I'm pleased to tell you all, Festivus is back. And for those of you who don't know, Festivus is a holiday tradition that was created by a man named Frank Costanza. When he decided that the Christmas holidays were not satisfying to him in having a retrospective year, and instead decided to create a new holiday because he determined there had to be another way, which is a good theme for us here. So welcome, newcomers. The traditional Festivus begins with an airing of grievances, all the ways in which we've been disappointed over the last year. And we got a lot of problems with you people, and now we're going to hear about it. And so the people I have on the panel to tell you about this are, of course, extremely distinguished defense counsel across the courts and tribunals. Their bios are so long, I would go past my own time frame here, so I'm going to just give you some highlights. First, we will hear from Dr. Felicity Gary, KC, who practices in England, Wales, Australia, and of course, ICL. She's practiced not just ICL, but also terrorism and human trafficking cases. She works in the Al Hassan defense at the ICC and Mr. Bazrati at the KSC. When she gets out of law, sometimes now and in the future, I would like to let you know that she enjoys thrifting and antiquing. Next, we'll hear from Mr. Gio Suzuki, who has been a lawyer since 2015 and is on the defense team, was on defense teams at the STL and, of course, the Mechanism at the the ICC, he worked on Al Hassan and is currently on the Ekatam defense team. And sometime in the future, he will be taking up paragliding. We get to Miss Carrie-Anne Rohan, of course, next, who is of the New York Bar in England and Wales. She's at 25 Bedford Road, Chambers. She is currently working on the Thatch et al. Case in the defense of Mr. Vesely. Previously, she worked on the Haradinaj case, and she will be in the theater one day. Mr. Dr. Dub Jacobs is a French and ICL expert who is a defense counsel at the ICC, the NICT, cases of Bagbo, Kabuga. He's been duty counsel at several institutions. He's the founder of SILC, the Strategic International Legal Consulting. He's been an amicus curiae in Afghanistan and the Palestine situations of the ICC. And when he's not doing this, he likes to play Clash of Clans and make sure his children grow up properly. And Ms. Kate Gibson, of course, one of the founders of this Feast of Grievances, has been representing accused since 2005. And I really can't get into all of the cases she's worked on. Taylor, Karadzic, she's worked in Chambers too. Of course, you maybe know about the Rusabinga work that she did. She's currently an associate counsel of for Joseph Kony, in representation of Joseph Kony at the ICC. But she's worked, of course, on the Bemba case at the ICC, the Uganda case, and is also currently working as a counsel in the Thatcher case of the KSC. She's an ADC past president as well, currently vice president, and sits on the ICC executive. She is also an associate tenant of Doughty Street, and in the future, Kate is going to nail being a professional sleeper. Something probably familiar to everyone in the room. So, to the panel, I have brought the Festivus poll, which is, of course, a sand timer. Very effective, pro tip, with people, with lawyers in particular, in keeping people to time. This is approximately just under 5 minutes, I'd say 3 to 5. So basically, if you see it run out, start thinking about wrapping up. But what is, to the panel, your fair trial grievance of this year? Let it be aired to the people. Let us know what in fair trial rights has been a grievance that you've had this year. And of course, starting down here with Mr. Gary.
Okay, so my grievance is not new, and it's not novel, but I think it's true that in my experience, defence counsel should be involved at a much earlier stage. In both of the cases that I'm in, Al Hassan at the ICC and Mr. Bhattacharya's case at the KSC, really it would have been really helpful to have had at least a defence representative at the investigation stage for several reasons. Not just as a sort of a unique opportunity under Article 56, but because evidence is collected by NGOs who don't really understand what courts do and may have a particular agenda, because security issues are sometimes raised later that wouldn't exist if it was a joint investigation. Now we have the uploading of digital evidence that will need massive management, and we don't really know how that's going to work, but you can bet your life it will be ever so difficult for the defence to examine it after the event. And there's just this huge lack of equality, it seems to me. As a joke, I got my daughter to put my face on a bunch of photos of Karim Khan and sent them to the team as a bit of a joke, and I think Melissa's in the room, she might remember it. You know, shaking hands with all and sundry going around the world. I think that the court would have much more credibility if it was both the prosecution and defence shaking hands around the world. And changing it to a sense of equality and having us involved in interviews, making it compulsory to have a lawyer at interview, at the charge stage, or even the issuing of an arrest warrant. So the defence perspective is in there as an argument at the very earliest stage. You can't be sure that the judges who sit on these cases at any stage have great defence experience. We are an unusual beast that poke the system with a sharp stick for ethical and genuine purposes, and I don't see that happening at all myself in the cases that I've been in. And even when you do an amicus curiae brief, the vast majority of those are happening at the appeal level. But if the issues that you raise are really important, like in Ongwen, when I raised the non-punishment principle in the context of former child soldiers, that should won't necessarily know what I did for my PhD. You know, and there are excellent academic advocates who are also counsel. There are expert panels now for the prosecution to rely on. It starts to become difficult to find an expert for the defence. And actually, if they are experts rather than advisors, then we should be, as the defence, seeing what they're saying at a very early stage, being able to challenge levels of expertise. So in all these situations that sort of look good for the prosecution and the court, don't. They really don't. It isn't a sense of equality, it doesn't work, it means we're inhibited when we try and defend properly, it causes delays, things that could have been sorted out at a very early stage, and it might make a difference as to whether somebody is arrested or not. It could make a real difference to years and years and years of people's lives, and it could make a real difference to those people who have to wait for their reparations. You know, we argue a lot that reparations shouldn't be tied to convictions, that they should have come out of the situation. If findings are made about a situation, then reparation could flow even without a conviction. Well, we might be able to identify that at a really early stage if we were involved at a really early stage. And I get the ethical issues, you know, you might not be able to go on and defend an individual if you were the person that was involved early enough. But look at us, there's loads of us in the room, that could be managed. So lack of equality needs to be fixed. It's not novel, it's not unusual. I'm sure we've all been banging on about it for a very long time, but it's really extreme now that we're parked in a corner and don't have the visibility or the input that we should have. Makes me very cross.
Very succinct. Thank you very much. And very apropos to start off an equality of arms issue, especially when it's a growing chasm. You know, it's become not just little to me.
Yeah, it's huge and ridiculous, frankly.
We'll get more into that, but first let's go to Mr. Akio Suzuki. Do you have a grievance to air today? Fair trial rights only.
I do. Well, grievance is probably not the right word. We'll be in front of our judges in about 2 weeks, so it's going to be very diplomatic. Hello, can you hear me?
This one's good.
Thank you. Hello. Yeah, like I was saying, grievance. I'm not sure I'll characterize this as a grievance, but I would like to talk about the scope of prosecution investigative obligations at the ICC, and in particular the obligation to investigate exonerating circumstances and incriminating circumstances equally. I'm a little bit afraid of the sand timer, so I'm going to cut out some of this case context, but very, very, very simply, or very basically, one of the charges faced by Mr. Yekatom was the charge of conscription and enlistment of child soldiers. And the kind of evidentiary centerpiece of this OTP case was a demobilization program whereby 60 alleged child soldiers were demobilized from Mr. Yekatom's armed group. And long story short, it turned out that this was a fraudulent program. The participants weren't in the group, or they were they were older than they had been presented as. And so the defense sought to have much of this evidence excluded under Article 69(7). And the defense argued that the prosecution had violated its investigative obligations. In essence, the thrust of the argument was that there were many obvious indications in the prosecution evidence that the program was fraudulent and that these witnesses were not child soldiers, this kind of thing. And that the prosecution had ignored these basic investigative standards and had ignored the indicia of fraud in the evidence. So that decision was rejected. And I think there's two findings that are interesting for the purposes of today's discussion. So the judgment found that there was no violation of Article 54(1), so that the prosecution hadn't violated its investigative obligations. But in making that finding, it made a preliminary finding where it said that, where it cited the prosecution's independence and its discretion, and found that the trial chamber only had a very limited role in reviewing whether the prosecution had complied with its obligations. And the second finding that I think is interesting is that the trial chamber found that because most of the evidence that had been, or rather, the evidence had been ultimately elicited while the witnesses were on the stand and under the supervision of the trial chamber, it meant that it couldn't have been obtained by means of a violation of the statute. So essentially, the chamber required a very direct causal link between the violation and the obtaining of the statute. And Marie's asked us to talk about why this matters. And for the first finding, I think it's important, or helpful at least, to look at the drafting history of Article 54.1. And so this obligation is the result of a German proposal that was grounded in the idea that investigations in cases before the court would be particularly time and resource intensive in such a way as to significantly disadvantage accused before the court. And so hence the need to impose this obligation on the prosecution to collect exculpatory evidence, essentially on behalf of the accused. And I should add, this decision of the chamber represented something of a departure from past cases where chambers had been asked to review whether the prosecution had complied with its investigative duties, and in those decisions they didn't seek to impose or self-impose these kind of limits on its powers of review. Obviously, this is just one decision, and it's too early to say whether this represents a trend or anything like that, but I think, it's easy to see how this would potentially affect the fairness of proceedings if it does become a trend. Equality of arms issues, of course, and issues of who's watching the watchman type concerns. And in the second finding, I'll wrap up with this. In requiring this direct causal link between the violation and the obtaining of the evidence, the chamber followed the Al-Hassan trial chamber, which declined to exclude evidence that had been obtained from Mr. Al-Hassan while he was being held in detention and tortured in detention. And as I understand it, that decision very much turned on this quite a narrow and strict reading of the requirement in Article 69.7 that the evidence that is obtained, well, the evidence has to have been obtained by means of a violation of the statute or a violation of international human rights in the case of Al-Hassan. And so Article 69.7 obviously empowers chambers to take quite decisive action to preserve the integrity of the proceedings, which goes beyond just questions of fairness, trial fairness, but also issues like the core values of the Rome Statute or the international community's expectations. And there's also a related purpose, which is to discipline and deter law enforcement or unlawful or improper law enforcement, improper conduct of law enforcement. So kind of given the lofty and far-reaching purposes of this rule, I do think it matters that successive chambers have chosen to focus on this quite narrow, essentially quite a technical aspect of this rule, or at least to emphasize that part of the rule, instead of turning their minds to, or at least instead of expressly turning their minds to what I think are the more important questions of how this impacts the integrity of the proceedings and also assessing the prosecution's conduct in that specific context. Yes, those are the grievances.
Thank you very much. Thank you very much for that. Perfectly done in timing, so no worries there, of course. I haven't exactly expressed what the Festivus punishments are, for running through the sand timer yet, but hopefully we don't have to get to that. Thank you for pointing out, these systems weren't created, they're not really grievances. Of course, we're being glib. For anyone who didn't catch its humor. The grievances part, it's really just expressing, they've created a system in the Rome Statute particularly here, a specific provision. We didn't create the system. I don't know that anyone on the panel was in those discussions, maybe, but we didn't put the system in place. We're there to make sure that it's respected, and the rules that were put there are upheld in full, not just as the most narrow construct. So thank you for pointing to that specific provision, because it doesn't exist in all the courts and tribunals, and therefore, since it's here, how does it get fleshed out? So that's an interesting angle to put on this today, so thank you for that. We will now move, of course, to Carrie Ann Rowan, down at the end of the panel. Do you have any grievance concern that is legal?
Of course, considering our trial is ongoing, I have no personal grievance and of course no personal opinion to share on ongoing proceedings, and nothing that I say today should be construed as such. But there has been a recent filing by the defence in our case that some amongst you might think could be perceived as a grievance, and that is a motion in relation to judges' questions. The filing is called the Joint Defence Request for the trial panel to take measures to ensure the appearance of impartiality of the proceedings and to avoid prejudice to the defence. Now, I'll try not to go over my sound timer, but to understand how we got to this, we kind of need to understand how we got here to begin with. The Thatchy case began here in evidence in April of last year, and within 10 days of the first witness, this issue was up in front of the appeals chamber. The defence had immediately objected to the manner in which the judges were asking questions of witnesses and raised the issue with the panel. Now, the panel took the view in April of last year that they understood themselves to have a broad and unconstrained power to question. That was brought up up to the appeals chamber, who found that the judges can ask any question at any time. Now, of course, there's nothing wrong with that in principle, but of course, all powers have limits. And the limit that the appeals panel put on that power was, that's all well and good, provided that such questions do not lead to the apprehension of bias, suffering of prejudice, or otherwise encroach upon the rights of the accused. Now, I'm sure we're all familiar with case law in relation to appearance of impartiality, duties of judges not to investigate cases, but are really to be the neutral referee in the room, as well as, in this case, the finder of fact. But what's happened since April? So this was April last year. We have this filing last year. We have had a year of judges questioning, and two issues may be of interest. One is the manner of that questioning, and one is the volume of that questioning. So in terms of the form that questioning is taking, we have had questions from the panel on a regular basis, which are leading questions. We have questions that, we have questions that put inadmissible evidence to witnesses. So we have a practice that's developed by the panel whereby a judge will rummage around the unused material, take evidence upon which the prosecution do not seek to rely, evidence that has been served as unused or served as exculpatory material, and read it to a witness into the record and ask the witness to comment upon it. Ask the witness if they share that view, if that is correct, if they have any reason to disagree with that, and thereby introducing into the trial record inadmissible evidence by way of having the witness confirm that to be true. Again, evidence that does not form part of the prosecution case. We have questions that come from the bench which begin with the words, "I don't want to put words in your mouth, but," which is a very frequent occurrence in our courtroom. We have questions that invite speculation. We have questions that ask for rumour. And we have questions that ask for multiple hearsay. We have questions which are open to an interpretation that the panel is seeking to impugn witnesses that neither prosecution nor defence impugned in advance of their questioning. And we have questions on the bench which an objective observer may think seek to bolster the evidence of prosecution witnesses. Now, in the filing, it has been argued that one might think it exceptionally dangerous for judges to suggest testimony to witnesses, given that witnesses inevitably tend to view judges as authorities whose suggestions should be followed. It's the classic "you trust the man in the white coat" fear with putting suggestions to witnesses. In addition, I mentioned the reading into the record of inadmissible evidence. Another issue arises with that, and that's notice to the defence. So while the judges are doing this, we don't get notice. We raised this issue back in spring, and an oral order was issued whereby it was decided that the panel should endeavour to give us notice if they are going to use unused material that the defence don't expect. 2 weeks ago, material of that nature was used and objection was raised that no notice had been given. The response we got was, we're only entitled to endeavour to give notice. And the questions proceeded. Last week, the week just gone, we received, after examination in chief of a witness, 2 lever arch files of documents that the panel told us they intended to use in their questioning with the witness. So midway through a witness, 2 bundles of lever arch files, and we're told we intend to ask about this. No notice, no additional requirement to do anything about that. So that's where we're at in terms of the practice that has developed with the manner in which the panel asks questions. So what has the defence said about that? Oh no, before we come on to what we said about that, I'll just deal with timing, and then I'm probably over my time around. Well, okay.
No, it's really good.
Okay.
You can have my time.
I'll go to this. No, you're
Oh,
fine.
it's quick.
Just
go.
keep going.
Right, so a statistic that may be of interest also, so that's the manner of the questioning with which we're dealing. The second issue is timing. Now, the vast majority of witnesses in our case, all bar none, are 154 witnesses, so witnesses where their examination in chief is given on paper. So one might expect that the vast majority of time spent questioning should be by the defence, as prosecution has their chief in on paper. But I'll share with you the statistics as of the 11th of November of time spent questioning in court. Prosecution, 201 hours. Victims' counsel, just under 9. Defendant number 1, 154 hours. Defendant number 2, 54. Defendant 3, 52. Defendant 4, 49. The panel, 71. So the panel have spent more time questioning witnesses than 3 defence teams, individually, not collectively. So that is the volume of this questioning that we are getting. Now, because that occurs, there then has to be questions that follow that. The questions that follow that, as of the 11th of November, the defence have had to spend 31 hours and 23 minutes collectively dealing with the issues raised by the panel. The prosecution have spent 12 minutes. 12 minutes versus 31. Now, what the filing has said in relation to that is that that statistic cannot be perceived by a reasonable observer to be even-handed, because without question there is a perception by the prosecution that they need no more than 12 minutes in response to 71 hours of questioning to deal with the issues that arise, but the defence deem it necessary to take 31 hours to deal with it. That's more than 100 times that of the prosecution. Query whether or not issues around perception of impartiality arises, and whether or not the prosecution do in fact perceive there to be any challenge to their case coming from the panel. What we have said in the filing is that the judicial questioning is creating the impression that the panel does not challenge the prosecution case, but instead is using the bulk of its time and directing the majority of its questions towards inculpatory topics, leading to the clear impression that the presumption of innocence of the accused is not being respected. The The overwhelmingly one-sided manner in which the judicial questioning has been conducted in this trial has created an apprehension of bias that the appeals panel expressly cited as a limitation on judicial questioning and has violated the rights of the accused to an independent and impartial tribunal. And that's where we were as of the 13th of November. Some may forward agreements. Apologies for going over time.
You're perfect. This is actually a little under. It's a little trick. Thank you very much. You can see we've gone from pre-trial seeping into the trial phase, and issues that we maybe used to be here on a panel about, whether we're talking about inadmissible evidence, quality of evidence, hearsay, usually those were directed at prosecutor interventions, and now we're talking about it in the sense of judicial interventions, which is a new layer that we need to look at how it impacts the trial, and thank you for bringing us directly to presumption of innocence. So thank you very much, Karen. We will now move to Dr. Jacobs for only one, maybe 1.5, 2.
I'll use my time.
Okay, within the time, as many as you have. Go.
Okay, thank you. So my main grievance is that new update on Clash of Clans isn't perfect. We can discuss this during the break. You were quite elegant in the way you presented my relation to my kids. Because I told you that I was trying to not kill them on a daily basis. But, so to follow your logic of going from trial to after trial, I'll start with Saeed briefly, and I put the same caveat because we're still in trial. But I'm going to criticize the prosecutor, so the judges are safe on this one. There's really two issues which I want to raise. It's not spectacular, it's not original, but because we are doing this, this is an ongoing issue. I can mention that it's still an ongoing issue despite years of discussing it. The first one is disclosure obligations by the prosecutor and obstruction to actually give stuff when we ask for it, even when we justify it, despite the fact that we shouldn't have to explain to the prosecutor our minute strategy and what specific issue in our defense case we're supporting with the evidence we're asking. We are generally quite kind with the prosecutor and we give him a general idea, and despite that we have quite a lot of rejection and refusal to disclose evidence which sometimes is particularly relevant. And one issue, for example, recently I can mention is the issue of the nature of the armed conflict in Central African Republic in 2013 is in the charges, whether there was an armed conflict or not. And the prosecutor alleges that there was. And one of the reasons he says that is that the Anti-Balaka were organized already in 2013, which we think is not true, but that could be for the trial. And the prosecutor alleges that one of the organizers of Anti-Balaka in 2013 was Maxime Moko. And we all know here that the charges were withdrawn against him. So we've asked for disclosure of certain information relating to why the charges were dropped, and if factually this helps us, because on the one hand the charges are dropped in his case, and then on the other hand the trial brief in my case mentions Maxime Moko as a senior anti-Balaka leader, which explains that the anti-Balaka was sufficiently organized in 2013. So it's a reasonable request to ask for information about that, but it has been mostly denied. So this is being litigated despite the fact that this seems pretty obvious. And to give a very mundane example, but even in terms of disclosure, the prosecutor systematically denies, sometimes he accepts grudgingly, but to disclose the ID that the witness gives when he's doing a prior recorded testimony. This seems like an obvious document to give the defense for purposes of identifying the witness, etc. But often we're told by the prosecutor, just trust us, it's him. Just trust us, we redacted a phone number, but it's the witness's phone number. Or, that's the answer we get. So that's a major problem. I had the second one, which I won't discuss, which is overuse of Rule 68, like prior recorded testimony, because I think everyone who has had experience in ICC trials can probably testify to the fact that not one witness ever comes to purely confirm his prior recorded testimony. And this should at some point this should get the judges to think, concretely. We can discuss the theory of whether this is good, whether this expedites proceedings or not, but I've been in 2 full trials at the ICC so far, and again, I don't have one witness who under cross-examination does not at least contradict or add or say, I've had witnesses say that's not true. They're being read their prior recorded testimony and say, I didn't say that. So when there's such an accumulation of that, the practice of overusing Rule 68 testimony should be revised. Now, one point, this is old news. So I'm no longer in the Kabuga defense team, but I can still talk about what's going on. Brief background. So Kabuga was found unfit to stand trial in 2023 after a long and I think way too long process. The trial phase started with him being unfit, in my opinion, but the trial chamber finally accepted that he was unfit. This is another issue which I won't go into, but decided to order an alternative, basically continues the trial without him, and this was overturned in appeal. So in August 2023, and the appeal chamber ordered that his provisional release should be a priority. He's still in detention. Now, I can't go into too many details, but basically it's been difficult to find the country to take him because the countries don't want to. This is being litigated in some detail. 2 interesting points is, one, the chamber is considering the Honda option, with the prosecutor making grand statements of how Honda is a democracy, that Kabuga would be safe there, that it's an amazing place to send him, despite the fact that he'd have, other than the fact that his life would be threatened, he has no family, nothing, no support there, obviously, sending Kabuga to Honda, or the fact that he can't actually travel there given his health. But this is even on the table as an option was crazy for me, just to put it in summary. And the second thing is, there was a recent public decision by the presidency, where, and this would be a nice transition to Kate, where the defense team of Kabuga actually argued that he should be allowed to go in an apartment in The Hague, which would be considered as the premises of the court, so that he could have care with his family, etc. This, as was done in Bigude and Mokom, but maybe Kate can clarify that. And this was rejected, saying the only detention place in The Hague is a detention center. We don't care what the ICC does. We're not going to consider that option. There is no evidence that that he's not well cared for in detention. Fine the state, but we're not going to follow that option of doing a premises of the court option as the ICC did. So I'll stop there. Sorry if I was too long.
Perfection. You've all been remarkably on time, so no worries about that. And thank you for bringing us sort of through the trial again back to disclosure issues. And I feel like this has been since tale as old as time. We've been discussing that in this very room on this very panel quite a bit, and there's still quite a bit of work to be done. And taking us into then, of course, really the start of what happens after, and what we do in these specific circumstances when persons are found not fit. We're 30 years into this ICL experiment, and we don't have the answers yet on a lot of these things, and it's not. I would say these are personal opinions I'm giving you today, by the way, not official ICC positions. I think we should be there. We should be there with some answers. And unfortunately, I'm going to turn to our fortunately for you, to hear from our final panelists, but unfortunately, I think the thread, as Doug said, may continue through in some of our unanswered lingering questions, aka grievances.
International courts should not be detaining people when they don't have a plan for their release. International courts should not be detaining people when they don't have a plan for their release. Their provisional release, their final release, whether that's after an acquittal or a conviction, you cannot be locking people up when you have no idea on God's earth how you're ever going to get them out again, when you have no framework in place and no states who are willing to take people when they come out of prison. There are a number of us in this room who've been dealing pro bono for years and years with the mistakes of the tribunals. For me, this is just the most shameful aspect of the entire ICL project that no one is trying to fix. The worst example is the 8, now 6, former defendants of the ICTR who were either acquitted or released and who have been detained illegally in this terrible situation in a house in Niger for 3 years. These were men who were in a safe house in Arusha after they'd been released by the ICTR, and after a series of terrible missteps by the mechanism, they were transferred to Niger, where they were supposed to be given identity documents and ultimately passports and be allowed to reunite with their families. They weren't. They were rounded up, stripped of all their identity documents and put in a house at gunpoint, and they've been there since December 2021. 2 of them have died in the house in extremely distressing circumstances for the 6 who remain. My client, Prosper Mugiraneza, who's in the house, who I first met in Arusha in 2005, he was acquitted of all charges by the ICTR in 2013, and he thinks, and he's probably right, that he will also die in this house because the ICTR detained defendants without ever putting in place a plan for their release. And I really believe that a lot of people who work around international criminal justice have no conception of the day-to-day reality of detention, of what it does to someone to incarcerate them for months and years, what it does to their mental and physical well-being. And we as Defence Counsel have to watch this. We watch our clients deteriorate, their capacities diminish, they become unable to process information in the same way as people who are at liberty. They can't perceive things in the same way, they can't process things from the outside world. And we've decided as a community of ICL practitioners that we're fine with detaining suspects and defendants when the conditions for incarceration are met. But what about the fact that we're detaining them when the conditions of incarceration aren't met? We're talking about post-acquittal detention for months and years, and it keeps on happening because international courts detain people without a plan for their release. And the ICC is repeating these mistakes. When my client Jean-Pierre Bemba was acquitted by the ICC after 10 years in June 2018, the ICC did not have a plan for his release. He couldn't walk onto Dutch territory. It was in chaos. The ICC registry had no memo somewhere in a filing cabinet saying, okay, this is what we're going to do if Jean-Pierre Bemba is actually acquitted instead of convicted, like we all hope he will be. There was no plan. Now the current Vice President of the Congo and the ICC had no plan. When our client, and I hope Philippe Larochelle will talk more about this afternoon, Maxime Mokum, when all the charges against him were withdrawn in November last year, the ICC had no plan for his release. He was detained illegally in a hotel room for 43 days, then threatened with immigration detention in the Netherlands. Now he's living in terrible conditions in another European state. He is openly suicidal. He has no ability to get back to his family, to his kids. He doesn't know where he's going to live. His life is ruined. This is such a scandal. And we can't say that we're having fair trials when international courts are detaining people in circumstances where an acquittal can actually be an effective life imprisonment.
Thank you, Kate. Succinct as ever, taking us through that and these final stages. And in the ways where, again, in my opinion, we create more victims in this by not having these plans and these processes, which we could have anticipated and should have anticipated, and then we're told about. And then we're told about it again and again and again, because I think last year, the year before that, we've sat here and had the same discussion over and over. The ADC has done, under I don't know how many different presidents, and ever present, issued a number of press releases, has done a ton of work to try to find solutions. The attorneys on these cases have worked pro bono for years. For years they've worked on this, paying out of their own pockets to actually do this. And And this is one, I completely agree, this is one of the most egregious, it's a human rights situation that we have created here, and it is something that we will continue to talk about here, of course. But hopefully we don't have to. Maybe next year we can talk about something else. Hope dies last. But to that end, I want to go back through the panel, and this is why we've been a little bit strict on time, and thank you all. You were absolute gems on time. I want to go back through the panel and see if you had any quick thoughts on each other's interventions. Because maybe these are situations you know or experienced in your own cases, or maybe it's something you just have a thought on. And so I just want to go back through, maybe in the same order, if you have any thoughts. You can also pass, but...
Oh no, I'll never pass. I'll never pass.
This I know. I'm sure that everyone has thoughts.
Yeah, look, working backwards through all of this is it's completely shocking. It makes me want to immediately write to, in relation to any forthcoming arrest warrant, to say, what is your plan for release? And just appalling to hear what Kate says. It's abominable. It's another reason why I think I'm right, that we need to be involved at a very early stage. And actually, just picking up on what you said, Marie, you said we didn't create the system, we're there to make sure it's respected. Well, frankly, you can't respect a system that works in the way that Kate suggests. So actually, the system has got to change. And although we will feel that heavy burden as how on earth do you change this system that is so weighty on us already, it's so hard to defend in these cases, somehow, collectively, we've got together and say these bits of the system are not working. We want to respect this system. We think it's really important. We're here because we want to uphold a system that is relevant and important and capable of being respected. But these issues mean that it's losing that respect, or it's lost, which is a real problem for the system as a whole. And then obviously, hearing judges who think they're in some sort of inquisition or inquisitorial system that doesn't respect the ways in which advocates prepare cases to make sure they're presented properly is equally appalling. That you're having to deal with 71 hours of judicial intervention when they won't have been, if they're not preparing them and they're not giving you advance notice, then it isn't really being thought through properly, and the impact of those judicial questions, biased or otherwise, I appreciate that's the question that's out there to be decided, biased or otherwise, first of all, you're wasting a whole heap of time, hundreds of hours that advocates are there to keep cases efficient. But secondly, you're creating a whole case that wasn't investigated at the beginning, that might make a change that affects everyone. And thirdly, you're neutering the prosecution. If the prosecution going, oh, we only need to do 12 minutes, then they have no value. So we're up against a team that has either no value or no ability to frame what the judges are doing, and we need to be against equals on the other side of the courtroom. So actually, what's happening is it's browbeating the prosecution, who should be standing up to the judges and saying, no, that's not how this system works. So we lose our adversary as well. We're losing those that we're meant to be against, and we're suddenly targeting the judges, which you can't respect, because you shouldn't be targeting the judges. They shouldn't be putting you in that sort of situation. And because you only said one, I think I'm going to say CC above everything else that was said by Dov, because ultimately what you do is lose respect for a system that we've got to be able to respect. It's got to be important. We have to have equality. We don't have it, and it's affecting people's lives. The result is that you see my vulnerable, not well client held in detention in the Kosovo specialist chambers. You see Mr. Al-Hassan not well. Everyone understands the issues why he's not well. There are questions on appeal that I'm not going to talk about now. But suddenly you're making people sick, killing people in a system that is meant to be doing quite the opposite.
understand it, one of the justifications for the withdrawal of charges was the withdrawal of cooperation of a number of witnesses that the prosecution had put forward for a case against Mr. Malcolm. And a lot of the witnesses, just in general, there was a lot of crossover between the witnesses in our proceedings and those that were going to be called in the Malcolm case. And some of those witnesses were really quite close, I suppose, to Maxime Malcolm. I think I can say that much. And so if you have this withdrawal of cooperation so fundamental that the Maxime Malcolm case collapses, you would think that there would be at least some of the witnesses that the prosecution is relying on in those cases may have testified in our proceedings already, and that is, you'd think that would be something that is important for the defense to know in Yakutum and also in, I suppose, in Said. And the prosecution completely flat-batted that and said, we don't need to give you that at all. It's completely speculative, and that's where that ended. About Rule 68.3, in our proceedings before, the prosecution kind of indicated that it was going to be heavily reliant on Rule 68.3 in their proceedings, and the chamber said it was something like of 150 witnesses, only 25 were going to be fully viva voce. That ended up being a bit more of a reasonable proportion by the end of the case, but the chamber did say that it was an unprecedented use of Rule 68.3, but it did say that it was case by case. And I do agree in the sense we do see all the time witnesses come and say, yes, this is a truthful statement, I adopt it, or I've already made corrections, and then in cross-examination they recant absolutely fundamental allegations. One of them, for example, was hearing whether Mr. Yakutum had instructed people to murder Muslims. Under cross-examination, it was just recanted like it was nothing. He just said, no, actually, I never heard that. So there is a kind of tendency there to take Rule 68.3 statements as gold, as reliable, and then the onus is on the defense to wade into these extremely prejudicial allegations and take the risk of allowing witnesses to expound on them or something like that. I think those are the concerns that we see in our proceedings.
Thank you. Carrie Ann?
Sure. I just wanted to pick up on something Felicity said about early intervention. Oh, this one. Yeah. Is that better? No. About early intervention. There are, of course, like some mechanisms by which there can be early intervention now, and that's primarily in interviews. So the one place where people at least do get to have us in the room with them is their suspect interview. However, it is almost useless to have a lawyer in the room unless that lawyer is given sufficient information by the prosecution to render their advice useful. What we have seen in our trial, our case is the KLA are the defendants. There are a huge number of KLA witnesses that have been called by the prosecution, many of whom are considered suspects. But what we've seen again and again and again in the interviews, which are now being admitted as evidence in chief of these people, is they arrived for their interview and told they were a suspect. And when they asked what they were suspected of doing, they were told they had no right to know. No right to know that they were a suspect, and that's it. Were they a suspect of a murder, committing a war crime, committing shoplifting? How can you advise your client as to how to approach an interview, as to how to ask questions, as to how to deal with that, whether to ask questions at all, unless you know what is the charge that they're facing? And then compounding that issue, you have situations where the prosecution then seek to offer assurances to those witnesses. Well, how can you advise on that cost-benefit analysis, or advise your client of what they seek to lose or seek to gain by entering into any such agreement with the prosecution when you've no idea the crime that you're dealing with? And so there has to be, even in the basic framework that we have in place, stronger protections for the rights of people who have the right to lawyers in those early investigative stages.
Mr. Battajari didn't have a lawyer with him. That's why I mentioned it.
Yeah. Thank you, Carrie Ann. Dove, any
Yes.
thoughts or none?
Wish. Okay, just on the general point you made about respect for the system, and I'm known for a number of you here for being the one complaining on Twitter and LinkedIn whenever there's a conference that there's no defense on the panel. And if there is on the conference generally, and if there is a defense, it's a token defense person talking about the defense. And I've always complained that the prosecutor is invited to talk about cooperation investigations. The defense person should be on that panel. You don't just invite a defense person to complain about fair trial in one half the panel. So I'm happy that this conference is here, but it doesn't change the fact that, as you said, and I often say that, it's not a defense perspective. I've always hated the term. It's what the statute says. The statute provides for disclosure obligations. The statute decides for fundamental rights. I didn't write the statute. So we're here, I often say I'm a positivist. I'm not a defense-oriented person. It's written in the statute. And I'm just here to, and everybody should have that concern. It's not a defense perspective. So just to be very clear on that, I think it's important to say that. Two things in terms of comments. One, on the presence of the defense early on, I agree on principle. And I'm just a bit scared of the trap that it could be without the right information, and that you would legitimize an unfair pre-trial system without having sufficient powers to change anything, where the prosecutor later on says, oh, everything was unfair during the investigation of pre-trial, when effectively you won't have had the means or the legal basis to say anything to the prosecutor. There's also the risk, and people who have done the STL or the more recent Coney saying, well, and I did that with duty counsel at the MICT, where I find it difficult, you have no client. So you might, of course, and the OPCD does that quite well in principled arguments before chambers when PTC, but it stops somewhere. The OPCD doesn't go as far as to give strategies, or because you need a client and a defense counsel to decide the strategy later on. And however well-intentioned or theoretical we might be as defense counsel early on, it's not our strategy, and we might actually, even we're thinking of doing good, shoot the future defendant and his counsel in the foot of a strategy. We might try to exclude certain evidence where even maybe the client will say it's good, I want this in, and his counsel says I want it, and etc. I can multiply examples. So I just wanted to put that caveat. And the second thing, on Rule 68, there's also a question of format, and that's quite boring. But one of the reasons I think that there's such a problem is also the structure of prior recorded testimony, which is non-verbatim, which is a summary done by the investigators of the prosecutor. And after many years at the ICC, you can actually guess what happened. You see it, it's like you can divine. In this summary, this was actually following at least 4 leading questions. You know that. It's not written down, but you can guess in the way the summary is done that the witness did not spontaneously volunteer the size and the weight and the information about the ethnic group of the person. It was leading, and you know it, and it's there. But I want to finish on a positive note.
But if you had a defense person there, you wouldn't have to guess.
Yes. But then again, okay, I'll shut up.
We'll argue over coffee.
Yes, you could do it. Just something positive. You mentioned the proportion, about how many 68 versus viva voce, and it's similar in our case. But to be fair, at least our chamber understood, maybe not enough, but our chamber did understand that it couldn't all be 68. And you're going to say it's obvious, but the prosecutor was trying, for example, to get under Article 68, sometimes even 68(3), where the witness doesn't even show up. The unique witness for one of the confirmed incidents at the OCR. And we're like, that's not possible. This is a confirmed charge, confirmed incident, which is at the heart. You can't just say, oh, I'm introducing his prior recorded testimony and I've proven it. And the judges accepted that. you know, again, you can say low standards, low expectations, and also they accepted that they revisited their decisions where they'd accepted 68 witnesses, but as the trial was going on, they said, okay, this is becoming a real contentious issue, so even, we're going to requalify. And again, they might have not done it enough, but I just want to, we're expressing grievances, but it's also nice to say that sometimes the judges do understand, maybe not enough, but that, you know, when there's a real contentious issue, they requalified 68.3 in viva voce on certain matters because they realized that this required a full examination and cross-examination. So,
Kate?
I love this panel. It was a really good idea, just to let everyone unleash. It feels really cathartic to be doing it in like a conference centre, as
hello, my name is
opposed to
Doug
like in a
Jacobs, and I
bar.
haven't complained in 27 days yet.
Normally we're like crying in the defence corridor. It feels good to be here on a morning and saying all this quiet stuff out loud. It was interesting as Felicity was talking about the things that Defence Counsel should be allowed to do earlier, and they sounded just so foreign and outrageous, and then I'm like, no, of course that's right, of course that's right. And we just don't have that attitude in ICL. And I agree, we should be there earlier in the process, but I also think we should be there a lot later in the process and assigned and appointed and paid to deal with post-conviction and post-acquittal issues. And I sound like a broken record and I don't even care because it's so, I don't know why so many of us have had to work pro bono for years and years for our clients, for example in Niger, why we have to sort of beg and borrow from friends who are immigration practitioners to try and get them to help us, to help our clients. You know, why does it fall to the Defence Counsel to work unpaid on family reunification, healthcare? We're dealing with their, you know, and their resettlement and their immigration problems. And we are expected to do this, you know, yes, unassigned, and unpaid, but in our personal capacities, right? Which is really risky for practitioners and it's really exhausting. And we would love it if when these cases ended, they actually ended and we could close our file and go home, but they don't. The consequences of what these international courts do impact on the suspects and defendants for years and potentially forever. And the burden just falls to us, and it's a really, really heavy one, and we could use a lot more institutional support to try and clean up these messes that are not of our making. I only talk about this. I won't comment on anyone else's thing.
Perfectly fine. We have put these Sisyphusian boulders over everyone's head here, and they're the ones that all the defense practitioners face every single day in this and beyond. We only lightly touched on some of the issues. We didn't even talk about expertise. When we're talking about equality of arms, one of the ones that I see as a real frustration, if I'm to throw my own in here, just institutional support, the ability to grow institutional support within the prosecution in a way that the defense does not have capacity, whether it's just resources, whether it's structure, whatever it is. I was at a conference the other day where an ICC OTP in-house expert was talking about SGBC resources and dealing with witness issues with children and vulnerable people, and expressed that they had a special coordinator on SGBC. They had did training on interviewing children. They had developed their own best interest tool from collaboration of experience from scratch. And they had to do their own as it's specific to the place of and this court and the time. Monitoring rooms and interviews, psychosocial experts, country experts who can take notes and watch through the room while they're doing interviews of these persons. Training analysts to pick up on child-specific trends. And even where they don't participate in reparations, they talked about how they can seed information in a case for judges to consider in reparation. There was so much in this that I I just was trying to stay in my seat. Because I can tell you at the ICC, and I know this from a little experience, we don't have any sexual gender-based crime expert tool, resource, training available to the defense right now, specifically for all defense teams. And it's not because we don't want it, and it's not because we haven't tried to secure these things. We simply don't have it because of the way things are structured and the way things are looked at and viewed. And it's something that we need to build institutional capacity, if you're speaking to have these things, to have the nice things. It seemed really cool what they're doing over there. It seemed really important because we're talking about not re-traumatizing people. We're not hurting children. That's all something we can all get behind, right? Anyone else can leave the room. But it's something I think that we need to, again, look at. This is where I just have a frustration of all of this. This is holistic. Often the things we're talking about in the defense, it's going to impact the prosecution in their cases as well. It's definitely going to impact victims. It's going to impact judges in the cases, and so looking at it more holistically. But let's take it back to each holder, maybe. And back to the panel who is here to speak. I'm off my soapbox. I would like to pass back to the panel one last round, at least, to see, in Festivus there is a second part that is the feats of strength. The feats of strength here being, how do we solve these things? What's your answer? And a bit to the positive, thanks for bringing that in. What is the positive here? What is the answer to something? What's a piece we can put in and push for that's really going to help either on your own issue or something you heard today?
Okay, so the answer to all of it is we have to triumph humanity over process. That's the answer. It's not a practical answer, it's a theoretical answer that we've got to hold on to. I think the practical issue within the current system is everything we've identified now, we have to sort of look at those cases that are coming and almost work for nothing on forthcoming cases that we might not be involved with. This is what's happened in this case, don't let it happen in that case. I think there is a practical sort of amicus role we can play on the cases that might be coming. And there is something involved in, something we can do collectively to make those submissions and make what we're talking about here known. So that what we're saying in this room goes beyond this room. As to training on child-friendly interviewing, I've been delivering that in Tanzania and Kenya for Lawyers Without Borders for the last few months, and I've written about it for about 25 years. I would deliver that for nothing, but it should be paid. But I'll talk to Lawyers Without Borders as to whether there's a way. So we can also offer some practical assistance, I suppose. The fact that we're all here together is a good thing. I think we reflect at the end of today, and there will be some practical answers that we can achieve. I'm happy to be noisy. I suppose the other thing is keep being noisy. I know, Kate, particularly for you, you've been about as noisy as anybody could be on this issue, but I think we're all here to support you in that. And certainly the issues that have been raised by the rest of the panel, the support we have in the room is great, and I'm sure we can find things that we can do, however tired we are and however much sleep we need. So yeah, triumph humanity over process.
Thank you, Felicity. You will receive an email on Monday.
Yeah.
But the key point in there too, I just want to say, is, and this is to some of the points that were raised, especially Kate, you should be paid. And
Yeah,
we
of
should
course,
have people
of course.
paid for their expertise. Because
So
you
don't
can
remember
see,
the bit where I said I'd do it for nothing.
oh,
But, yeah.
right. But this is the point of the resourcing where it does, and I have not heard one word about legal aid here. Did anyone hear a word about legal aid? No, you didn't. What we're talking about is capacity here and also access and just doing the right thing in a humanitarian sense. So I think in that, making sure, everyone here, everyone out there offers their assistance all the time, and it is gold because we wouldn't have anything without it. But let's get paid too. Yeah.
Well,
No sand timer.
Yeah. terms of to return to the idea of Article 697, I suppose because the nature of the kind of case or the subject matter of the litigation that comes under that article, I think it's easy to understand, or at least it's something that's comprehensible. The offensiveness, for example, of using statements obtained from someone who has been subjected to torture, or allowing fabricated evidence to become part of the trial record. I think these are things that they are quite kind of comprehensible and quite offensive might be a strong word, but something that I think people who are not necessarily involved in, or not practitioners would quite easily grasp and comprehend and sympathize with. And so maybe for these kind of issues, some kind of recourse to not public pressure necessarily, but making a big deal about these kind of decisions and these issues in public might be a way to kind of pressure, or to kind of, pressure might not be the right word, but yeah, it might be the right arena to kind of deal with that, because for example, in our case, the practice and the prosecution is not going to change by itself. Essentially, we see the kind of evidentiary or the investigative failures that were the subject of the litigation in our proceedings. They kind of exactly mirror what happened in Lubanga 20 years ago, and we would have thought that was something that would have resonated with the judges, but didn't really seem to do so. And I understand it's maybe quite perilous for defense to also kind of make a big deal in public of decisions that don't go in their favor. But maybe this could be an OECD thing. I hate to go back to like that, Marie, but I'm not sure. Maybe publicizing these kind of things is
Making a list. I'm making a Christmas list, everyone here.
is the solution potentially, or a partial solution.
Positive. The positive aspect has to be us, right? You have to be your own white knight in these situations, and the one thing that hasn't, failed to amaze me is the tenacity of the defence in cases like this, and the refusal to become complacent in the face of what can often feel a completely relentless and futile exercise. But it's impressive, the stamina and the motivation that people on this panel, people in this room have to continue to fight and do motions and work and work and work to try to vindicate the rights we're there to protect. And I've never seen that falter, and I think that has to be the positive. And I think us all sitting here talking about it today, caring about it today, is indicative of that motivation. I guess it is a kind of a given trait of defence lawyers. You kind of have to be good at being a thorn in someone's side. But it doesn't wane over time, and it's good that it doesn't.
Yes. So structurally, I'm not positive and I'm not optimistic, because I think that, and not just in international criminal law, I think particularly domestically, there is always an imbalance between prosecution and defense. Those issues have not been solved, and I can talk for France. Talk to French lawyers practicing criminal law in France. There's no solution. There is an imbalance, and you fight. The idea, as was said, to make it better. But the idea that we're going to create a perfect system, that there will never be a bias against the accused, and I often consider that we over-exaggerate the pensions in ICL compared to domestically. When there's an acquittal domestically for massive crime or rape or something, there's outrage in the same way there's outrage internationally, and there's pressure on the defense counsel, etc. So we shouldn't overemphasize difficulties with ICL, but we shouldn't, as a result, be over naive that this can be solved. It can't be structurally. That being said, One very concrete issue which comes up when I hear Gio talking, and we have on the third floor of our one floor we have at the ICC, is sharing of information and knowledge. That's a real issue. The prosecutor will quote in footnotes in our filing something that they know from the Yekatom case, and even sometimes they would quote confidential filings from Yekatom which we don't have access to, and say this is case law which supports our position, and we're like, well, either you don't use it or you tell me what it says, because, and then we actually had to litigate that. It should be obvious that if you're quoting a filing in a footnote, I should have access to it to be able to discuss it, but that was litigated, and ultimately we got access. And that's an issue everyone who's worked in ICL knows, is that there's too much, there's lack of transparency, too many proceedings are closed sessions or private sessions, too many protective measures in my view. Again, I shouldn't have to, but I'm putting the caveat. The idea is not that we put witnesses at risk, but the balance for me is not struck in international proceedings between protection of witnesses and publicity of the proceedings. Too many decisions by email. That's been a big issue. Again, I'm talking concretely here for beyond the grand principles, but I can say everyone who's on the case now can testify, and who's been in the past, there's a shift here. And then what you have is that the decisions by email are published in one filing. So rather than being able to search a decision on disclosure, I have every 3 months a report by the registry, which is doing the job of the judges, by the way, just to defend the registry on this. The judges dump their job on the registry, and you have a registry report on decisions by email where you have 27 annexes, where it's impossible to do a search, or it's much more difficult to identify relevant case law, etc. So I could just multiply examples here where there is a lack of, and we talk in the corridors on public information, but just what Gio said is useful for me in Said. And of course I can search in the database, but it's different because the Office of the Prosecutor clearly has its institutional memory, which we don't necessarily have among ourselves in the defense team. So I think that's, again, it won't solve everything, but it's that imbalance that concretely can be helped, I think, marginally with certain tools, maybe a database at the OPCD, even on legal aid issues. I know that the registry is discussing to have a database on decisions on legal aid, because just to make you happy that it is mentioned, CSS, when they make decisions for additional means, etc., there's a lack of transparency. And sometimes we find out that we've been denied an extra legal assistant or whatever, and that another team got 3. And they did that as prescription, as you say in French, statute of limitations. In Bagbo and Liquide, there was an attempt to separate the defense teams when we were discussing means to after the acquittal. And we said no. The Bagbo and Liquide team are going to meet you together. And you're not going to use one against the other and try to negotiate. And I know that there should be a database of decisions, even redacted with details, but principal decisions on under what conditions you give extra means, under what conditions you increase cooperation, under what even missions, under what conditions you reimburse that kind of mission cost rather than that kind. All of that we have no clue. There is no sharing. Okay, I'll stop now. Sorry, but I just wanted to give a concrete example of improvement that is possible.
Thank you. Before we go to Kate, I can say this is in the works to try to get redacted decisions. This was raised a couple months ago. I'm hoping it can go somewhere as well. And even more concretely, I guess I don't usually announce anything that we do in OPCD, but to do publicly. But we did start collecting email decisions because they are impossible to know when you have all those annexes. What is it? Someone's actually gone through and put them into a system where we can figure out where these decisions have been rendered, because some of them are significant. Yeah, that'll be a tool for you if you want to maybe tell us how it looks. So, doing what we can, everyone here always. I will move now to Kate for a final word on how are we going to fix something, anything, one thing.
Okay. Yes. Every time that an international court arrests and detains a suspect, the staff of that court should sit down and put together negotiate agreements like this for the enforcement of sentences. The court has entered into agreements with states to be able to send people to serve their sentences in these states. It should give the same energy and resources to negotiating agreements for provisional release and eventual release. And every time we have these conversations with people in the ICC registry, formally or informally, they say it's not us, it's the states. States don't want to do this, it's not our problem. We can't get states to agree to accept people onto their territory. But that's the job of the ICC, to educate states, to put time and resources into explaining to them that their support for international justice can't be selective. You can't just support some aspects of justice that seem really exciting, like seconding your investigators to the Office of the Prosecutor to work on investigations in Ukraine, the front-end stuff, the arresting and surrender of people, the stuff that's exciting. You also have to cooperate and give support to the other side, to the back end of international justice. And there needs to be frameworks for what happens to people who come out of the other end of the international justice process. They have to have a chance to be able to live in dignity after having been a suspect and an accused. And there are 124 states parties who are coming here next week to stand up down the road at the World Forum. I'm saying this hypothetically because the defence aren't allowed to attend the ASP, but apparently there will be states standing up and, you know, proclaiming their support for the ICC and saying that they cooperate with the court, and they have to be told that your cooperation has to extend all the way through this process, because it can't just be left to us to deal with these issues.
Well, thank you very much to the panel. You are perfectly on time, consummate advocates. And we've taken away a lot here about, I mean, everyone in defense work, you have to be noisy, persistent, out there. Don't strive for perfection. You just have to get most of the way there. But share your info and knowledge and have a plan, not just us, but have the registry have a plan, have the court have a plan. And I couldn't agree more with all of your sentiments and all of your wisdom. In particular, just have a plan and have defense involved in the discussions to make the plans, because it feels a lot of times the plans are made without anybody giving input. And then the plans might not be exactly working the way that we want them to later, and then they end up as our Festivus matters. I'm going to turn the floor now then to you. Do you have questions, comments, interventions, Festivus airing grievances? Many.
I have questions.
Fill you the floor.
I would like to talk about legal aid, actually.
Go
Maybe
on.
not. So, and Kate, I'm sorry to disappoint, but that broken record I won't play this afternoon. So I think what I'm going to talk about, for example, about Tageroa, is that there should be way more than 6 people in that shitty house in Niger, and that's what I want to discuss this afternoon. For Macomb, I'm not going to talk about that either. What I want to talk instead is I want to brag about the fact that yesterday I met with the registrar of the court, Mr. And the discussions more or less went like that. I think you will find that interesting. So I asked Mr. Registrar, can I call you Osvaldo? And he said yes. And then he said, Mr. Philip, I have something very important to ask. I said, sure, go. And then he said, we need your help. We need your help to ward off these US sanctions, to enroll states to cooperate with us, to ward off the sanctions. And then I asked him, but you cannot even get those states to accept a provisionally released person when it happens. How are you gonna convince them to help you fight off US sanctions? I don't understand. Then we moved on to legal aid. But I'm asking you this question, we're talking about cooperation, and I think the fact that after 24 years of activity, this court cannot execute a provisional release decision talks volume about how effective it would be in trying to ward off US sanctions. And I'm throwing this out there to see what you think about that, and maybe what you think we can assess. Do you think we can help them to ward off these sanctions? I don't know. But I said, he said, help us. I said, pay us. Then Dominic dragged me out of the room because he thought I would not be invited again by him for conversations. But anyway, just to throw that, because I really think that their inability after 24 years to execute a provisional release decision will harm them a lot in now trying to secure state cooperation for what are really serious threats hovering over the head of this court. Anyway, thanks for the panel, by the way. It was very interesting, always to hear the record. We have a collection of broken records like that. I'll take another one for my intervention this afternoon. Thank you.
Can I just really quickly, if Philippe is not going to talk about Mohim this afternoon, can I just give 10 seconds of background on what he was talking about? Maxime Mohim, all the charges withdrawn last year by the ICC prosecutor after a confirmation hearing. He was detained as a suspect for 19 months. 8 months before he was released, the pre-trial chamber in our case said he's not a flight risk and there's no risk he's going to interfere with witnesses. So the conditions for pre-trial detention were no longer met. And they said provisionally release him if you can find a state. 124 states parties, none of them would put up their hands to facilitate his provisional release. So he remained detained illegally by the ICC. Just think about what we're saying. He was illegally and arbitrarily detained by the International Criminal Court for 8 months. And it's not because we didn't ask every state. We wrote to the President of the Assembly of States Parties and said, please talk to the states and get someone to take him. And she said, we don't intervene on individual cases. It can't go on like this.
I saw some other hands, and noting the time, maybe we can collect some of them here.
Marie, the question's for you because you've been there at the ICC for so long. We heard about 68.3s and we heard about how the prosecution sanitizes these statements, and then you have the witness going on the stand and saying, yes, it's truthful, and then Guillaume gave the example of witnesses who recant important parts of the statements. You have a lot of influence in the ICC statute and rules from Germany, from France. We know that when they interview witnesses, they have the questions, they have the answers, you have a full record of what they say rather than this summary made up by the prosecution. When Phil and I did the war crime cases in Canada, and we remember, Phil, we had interviews that were recorded, a full recording of the witnesses that they would bring to testify against our respective clients, regardless as to whether or not these witnesses are suspect. So why was this decision made that the prosecution doesn't have that obligation to record them so we can have a full idea of in what are the circumstances where the witness gave that answer? Was it the leading question? Did the witness understand? Was it misinterpreted? Because we often know that it's English investigators who go in French-speaking African countries speaking to witnesses. So was it lost in translation? We don't know that because we don't have the recording.
Yeah, and maybe we can move a microphone over here while I attempt to tell you I don't know in a more clever way. And again, the views of the author do not reflect the views of the ICC. I don't know. And I think part of this, again, when I go back to structures and systems here, the defense, I can tell you, at least from where I sit, is not included in most conversations about practice, procedure, policy. I don't know where they're even being discussed to know whether or not it's an internal policy that's adopted, and then we see in the courtroom, we have to wait for a case to litigate it to see if then how it's dealt with in the one chamber, but then another chamber may be different. And it could be plus minus, and as you've noted, based on the legal culture of the judges, or just their sensibilities about how they want to run the case. But that's one of the greatest struggles, I think, that I see in the day-to-day is on some of these procedures or procedural law. It is so inconsistent, and the ability to even find a pathway forward doesn't need to be this hard. We should have working groups that could come up with some of these things that come up. I know, don't laugh. That could actually discuss these things on this, again, back to, I'm going to say it, the structural equality of arms level, where we can work it out before we hit it. Oh, I'm sorry. That was ominous. Ooh, Festus. Before we hit it at some level of the trial where it's wasting people's times, whether it's the defendant in custody, whether it's the victims who are waiting on this, we don't need to do this and then do it again in another case later. Because we are literally on an island in these courts, we need to have some sort of more macular discussions of everybody at the table. And I can tell you, not only are we often not invited, when we ask, we're often told no. So to me, the inequality of arms that I see on the day-to-day is even lack of information, lack of knowledge. The legal aid decision, I don't know either on the legal aid decisions. We don't know, which is why it was recommended that we have redacted decisions. This was a recommendation that came up. Now, the question here is, how do we then, when we get these recommendations, which are frequent, whether it was in the independent expert report or audits, how do we make them enforceable as far as these are good suggestions? That's the question, because a lot of these things have been put out there as solutions. How do we actually put them in place? But we can talk more.
Can I just butt in just a couple of things? Sometimes I quite like it when the prosecution are running on paper and I can cross-examine a witness. So we maybe don't stand up for some issues as much as we could in an individual case, because it might work out helpful in an individual case. But what we're talking about here is what works structurally. So for example, witness preparation ought to be recorded, as well as the taking of a statement from a witness. Witness familiarisation perhaps should be recorded. And it's not hard now. And we're at a point where we're discussing the digitisation of courts and the more use of technology. So it's a good place at which we can say, if you're going to use more technology, use it in this place. So I think about it a bit like the submissions that I make to governments all the time on rights of persons with disabilities, vulnerable people, Afghanistan and the withdrawal, you name it. The stuff that we want to write about, sometimes we put it in academic articles, sometimes we say it at conferences. But I think we probably have to get good at making submissions to governments as a group. And I appreciate everybody's done that and had a go at that, but small things can sometimes work. There's a power in a letter from Marie. I mean, ultimately it's Marie's face that should be, the defence office's face should be equivalent to the prosecution officer's face, let's put it that way. That's what you're looking for, is a sense of a court rather than of prosecution publicity. So my instinct is you write a letter to every government directly of the state parties, to every president. You do something that sounds a bit silly, but might be linked just to publicity, but raises an issue that is so important it's being ignored because Marie's not being invited to the meeting. So I think on a practical level, the stuff that we think actually we're not so bothered about that in this individual case, but they're really bothered about it in that case over there, let's do something together, joint submissions on something, I think is a really good place to start. It's something that obviously we all do for nothing, and on legal aid I'm at the KSC, don't get me started. You know, but I think there is something collective that we have to do if the system is going to work at all, and this experiment is not working.
And I think, and when I said, back to the working group too, I agree completely on the states. I don't agree on the faces. I think we should depersonalize both sides, frankly.
Well,
but,
absolutely.
Yeah.
We're working within what we've got. I agree with that.
But I do agree with the states, but also the judges, and this is where, when I say a working group, there's a Chamber's practice manual. They worked very hard to try to, to try to come to synthesize practice. And if we could have, both parties and also the participants weigh in on some of the thoughts about what should be an established practice or evolution of I'm going to go through the panel and see if there's any last thoughts on anything that's been raised. Oh, I think that the question, if I can sum it up, and correct me if I'm wrong, is do we think that the chambers, or the prosecutors, sorry, the chambers of prosecutors have any grievances with the defense counsel in practice that we could reflect on as well, in a sort of self-reflection ourselves. Because noting that this is all defense on defense, so noted. I'm going to go back through the panel one more time and just see if there's any final thoughts they have on that, other issues, questions raised, or just closing. And I will actually start, maybe should we go from this end? I haven't heard down on this end.
Yeah, no, sure. I'm sure we drive them mad. I think the favourite response, or the most common response we get, is we've decided this already, go away. We get a lot of that. And I think there probably is an impatience on the prosecution with our refusal to be complacent and to take what are perhaps nuanced points, slightly different points, go at something from a different angle when there has been a change of position. And I'm sure there are many, many more. But that's the common refrain we're dealing with at the moment.
Off the top of my head, agreed facts. I feel like sometimes when now that we're at the end of the case, there may have been some things that have turned out potentially we were in agreement on beforehand. But I think there was a tendency to not really want to enter that discussion at the beginning of trial, and maybe that's something that can be seen as kind of unnecessarily obstructionist, but yeah, just off the top of my head.
One of the things I really loved about the ICTY and ICTR, my experiences there, was that we had great working relationships with the prosecutors across the courtroom. There was a lot of sparring, but at the end of the day, when the cases ended, we were all friends and we had a lot of professional respect for each other, and I think we were professionally very kind to each other. When I moved to the ICC to do the Weber case, I couldn't believe the level of hostility and the adversarial relationships between the defence and the prosecution. And I think it's only gotten worse over time, and we experience it at other courts around town. I think we all need to do a better job as an ICL community of trying to be more professionally respectful on both sides, because it saves a lot of time. You can agree things, you can exchange things, you can get things done inter partes, the judges like it. I don't know why it's going in the wrong direction, and we should all try and reflect on that. So thank you for injecting some balance into this debate.
Yes. Briefly on Philippe's point, which was ignored so far. Sadly, I think the two are not connected because it's a question of interest. So states have zero interest in ensuring, if you look at the Family Visit Fund, every week we have an announcement on LinkedIn or the website that states are giving money for the victims, the trust fund for victims, which is great. But ultimately, when we have, this may be unpopular opinion, but when we have so many discussions about the budget, about having trials, about having translators, interpreters, I do feel that states who are bickering about half the pole position as a prosecutor or defense or registry is then giving 20 million to the trust fund for victims. I think the priorities are wrong, to be perfectly blunt about it. That as long, first we have to make sure there's a budget, and before we're putting money in the trust fund for victims. This is a criminal court, first and foremost. It's not a trust fund for victims court. So that's, so I'm not sure that there's a correlation between states not wanting to have someone provisionally released and reacting to sanctions by the US. And also, states are afraid of the host state, the transition to legal aid. States, a lot of states, and you know that from your position, and I know that from my previous positions, ICBA, states actually agree with a lot of the ICBA arguments on the tax issue and the legal aid issue in relation to the host state, that basically the host state is getting back 50% of the legal aid budget back in its own pocket through taxes. That's not normal. Putting aside the fair trial equality of arms argument, The financial argument is pretty obvious, and yet they're afraid of the whole state. So, yeah, as long as, and that's why I will never be president of ICA, but they consider us external for tax reasons and phone and JWP and NUX, but then they want our help in ensuring cooperation of states. No, you can't have it both ways. Either you consider us as part of the court and the system in meetings and everything, or you don't. One final point, which was the question on, of course they complain about us, and I might answer a bit differently, is that one thing I didn't make friends in The Hague with as soon as I arrived here in 2009 is I raised the question of competence. You know, in conferences, I would say we're scratching our head about why this judgment says this and what did the judges have in mind. And I was very early on here, raised my hand and said, but maybe they're just incompetent. Statistically, that is true. There are incompetent judges, there are incompetent prosecutors, and there are incompetent defense lawyers. It's not possible that everybody's perfect. So I'm sure that in a particular case, in a particular issue, if we share stories, I've clearly seen people say, oh, the prosecutor in my case has been pretty open to inter partes and exchange of information. Honestly, I can say that in the Said case, it's been more conflictual, more adversarial, and so I don't think, and judges will not like one thing based on what Gil said. Ultimately, we don't concede enough. You know, we bicker about stuff, and we're doing our job. You know, agreed facts. I know that in the Kabuga case, we didn't want to accept certain facts which seemed obvious, but could have an impact on the general narrative and the contextual element. And actually, we played the game by sending back a proposed fact with an addition, which a prosecutor refused. Because you can't just have half. It doesn't exist in objective fact. It's all part of a narrative. And it actually proved my point when we sent back another objective fact that the prosecutor refused because it was a part he didn't want. And he kept just one half of the sentence. And so we don't accept enough. We don't accept enough agreed facts. We don't accept enough leading questions by the prosecutor. We don't accept enough, refusal for disclosures. It's okay, we get there at the end, we're all a family. You're bickering about a minor issue in a big case, and I think that, I'm not saying they're right or wrong. I think they're, my personal opinion is that we're doing our job, and the prosecutor has to prove his case beyond reasonable doubt. I'm not here to concede anything, bottom line. So I think that's the biggest grievance that judges and prosecutor will have of our defense, but ultimately that's our job. And one more, half a sentence. When I wrote this article about fair trial recently, I used that metaphor about, the defense is the mirror. We put up a mirror to the, like in, Snow White. We put up a mirror to the court who's asking who is the fairest, and they want the answer that they are the fairest. And they don't like us because we are the mirror, saying you're not fair. But we're not, don't shoot the messenger. We're just a mirror projecting back at you the unfairness of what you're doing. And so I use that metaphor, and I think ultimately that's why there'll never be balance, because we're the messenger. That we're just the messenger. And they have to accept the message or not.
Yeah, mirror, mirror, I've been the wicked witch in every production I've ever been in. I don't think what we do is accessible. We write brilliant filings, we're all really smart, it's not accessible, people don't know what we're talking about. So if we could improve our publicity, that would be magic. Maybe every single filing at the point it becomes public, do a summary, send it to the press office of the court and say, we want you to send this out, and if they won't do it, we're going to do it. And then have an argument about whether you can. I just think at the moment we suffer from why write one word when we can write 3002 because that's what we're allowed to write. So making ourselves accessible and making these issues receive greater understanding, I think is something that we really must do. Yeah.
Well, we were right on time. We woke up. So thank you for your questions. It really inspired even greater debates and discussions and solutions and positivity and being kind, as Kate said, over coffee. So, thank you for coming, and now we continue on with a Festivus for the rest of us.